Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about capacities of parties entering into a contract. Almost every transaction around us is the result of a contract. When you buy vegetables from the seller, you promise to pay him in money in exchange of vegetables. If you own a shop, you enter into two contracts, one with the manufacturer of the goods and second with the customer who will buy the goods from your shop. While buying vegetables, we might not pay attention as to whether the seller is competent enough to enter into a contract. However, if you are a shopkeeper, you need to check and be sure that the manufacturer is legally capable of doing so. This becomes important for you to hold the manufacturer legally liable for any default committed by him during the term of the agreement. The article deals with the legal prerequisites of a party before entering into a contract. Legal requirements for a person entering into a contract. Section 11 of the Indian Contract Act 1872 lists down the qualifications which enable a person to enter into a contract. A person should have attained the age of majority as per the law of the country of which he is a citizen. In India, the age of majority is governed by the Indian Majority Act 1875. As per Section 3 of the Indian Majority Act 1875, an Indian citizen is said to have attained the age of majority upon completion of 18 years. In USA and UK, the age of majority is 18 years as well. However, if a person is below the age of 18 years and a guardian has been appointed for him, he shall attain the majority at the age of 21 years. A person should be of sound mind at the time of entering into a contract. As per Section 12 of the Act, a person can be said to be of sound mind when he can assess, understand his actions, and realize the consequences of obligations imposed on him at the time of entering into a contract. A person should not be disqualified under any law to which he is a subject. Disqualification for entering into a contract. As per the Indian Contract Act 1872, all persons who do not meet the criteria as per Section 11 of the Act are incompetent to a contract. Hence, we can deduce that the following category of persons do not possess the legal capacity to enter into a contract. Minor. In India, a minor is an Indian citizen who has not completed the age of 18 years. A minor is incapable of understanding the nature of the liabilities arising out of an agreement. Hence, a contract with a minor is void ab initio and cannot be enforced in a court of law. The result is that a party cannot compel the minor to perform his part of the obligations as enumerated in the agreement. Mohari Bibi versus Damodas Ghosh. The respondent Damodas Ghosh, a minor, had mortgaged his property in favor of the moneylender, Brahmo Dutt, for securing a loan amounting to Rs 20,000. Mr. Brahmo Dutt had authorized Kedarnath to enter into a transaction through a power of attorney. Mr. Kedarnath was informed of the act that Damodas Ghosh was a minor, though a letter sent by his mother. However, the deed of the mortgage contained a declaration that Damodas Ghosh was the age of majority. The respondent's mother brought a suit on the ground that the mortgage executed by his son is void on the ground that her son is a minor. The relief sought to be the respondent was granted and an appeal was preferred by the executors of Brahmo Dutt before the Calcutta High Court. The same was dismissed. An appeal was then made to the Privy Council. The Privy Council held that a contract with a minor is void ab initio. Section 7 of the Transfer of Property Act 1882 states that a person competent to contract is competent to transfer a property. Hence, the mortgage executed by the respondent is void. However, if a minor enters into a contract and performs as part of obligation, the other party can be compelled to perform and fulfill its obligations. And in such instances, the contract becomes legally enforceable. A.T. Raghavacharya versus O.H. Srinivas Raghavacharya. A minor entered into a contract for mortgage with a person of the age of majority. The minor extended the monetary amount and performed his part of the obligation. The other party refused to honor the agreement. The full bench of the Madras High Court had to decide whether a mortgage executed in favor of a minor would advance the whole of the mortgage money as enforceable by him or by any other person on his behalf. The court ruled that the agreement sought to be enforced is a promise of the mortgage who is of full age to repay the money advanced to by the mortgage. The mortgagee who has already advanced the money, which was a consideration for the promise of the mortgage, and performed his part of the obligation. There is nothing pending from his side. Hence, the contract is enforceable. Additionally, a minor cannot enter into a contract and provide his consent when he attains majority. This is because a minor's agreement is void from the beginning. A void agreement cannot be made legally valid by ratification. Suraj Narayan Dubey versus Sukhu Hai. Suraj Narayan lent money to Sukhu Hai, who was a minor. The minor executed a promissory note against the money borrowed. After 4 years, when the minor attained majority, he and his mother executed a second promissory note in favor of Suraj Narayan in respect of the original loan plus the interest accumulated over the years. The court held the first agreement entered into by the parties is void as a minor is incompetent to a contract. The minor had no liability to pay under this agreement. However, the minor made promise and provided the promissory note amounting to consideration. A minor has no power to ratify the contracts entered into by him upon attaining the age of majority. In the second agreement executed by the parties, there was no consideration from the plaintiff. The original advance was no consideration for a second agreement. The second agreement is void due to want of consideration. Thank you.